Well, yes. So sorry about last week. It was, yeah, just a outage in the neighborhood. And then like half an hour later, I got a text from Spectrum saying that they were having issues. So that's why I couldn't use my hotspot. So yeah, we'll just finish up with the listing contract, and then I think we were almost done when that happened. So then we'll get into MLS statuses, what they mean, and then just quickly go through like the different kinds of listings that one can do, or yeah, just the different types of listings. Okay, so the extension of listing, I had gone through what a protected buyer was when we were discussing excluded buyers. And this is the provision that allows for protected buyers when somebody takes over another listing. So if a listing expires without it selling, then everyone who has shown the property, made an offer on the property, or saw the property at an open house becomes a protected buyer for that listing. So, and up to 1 year. So if a buyer who had seen the home during the time that it was listed with that broker, and they come back to it within that first year after it expires, then the previous broker is entitled to that commission if the protected buyer writes an offer and it gets accepted and it closes. So if it's a case where we, as a listing brokerage, took over another listing that expired, and a protected buyer comes back and makes an offer, it gets executed, then we step away from the transaction and we just connect that buyer and their previous brokerage, the seller's previous brokerage, together, and then they'll facilitate the transaction from there. And then likewise, if we have an expired listing and it moves on to another brokerage, or not moves on to another brokerage, if that buyer comes back and maybe gets in touch with the seller directly to try and work something out, the seller is obligated to come back to us and let us know that a protected buyer has sought interest, and then we'll step back into the fold. So that's why it's really important to get those protected buyer letters out. You've got 72 hours to get it out after your listing expires. And it's sent directly to the seller via mail and email. And again, it just lists those buyers or those prospective buyers who have seen it during the time of our listing. And it's happened before where buyers have circled back around. And I kind of probably spending more time on this than I normally would have, but we are seeing listings expire now. So I had to sign 2 protected buyer letters last week. So it's coming back. And we'll probably talk about this in a meeting, actually, either probably next week. Just reminding people buyer protected letters and protocol. So occupancy. So unless otherwise provided, seller agrees to give the buyer occupancy of the property at the time of closing. So when you're going through your listing presentations, just reminding sellers, you're actually going to give up occupancy at the time of closing unless there's a post-close occupancy agreement in place. Leased property. So if the property is currently leased, leases will extend beyond closing. Seller shall assign seller's rights under the leases and transfer all security deposit and prepaid rents. So if you've got a seller, investor, maybe it's a seller who owns a duplex and they've got 2 renters in there, and the renters' leases are beyond an expected closing date, we need to remind the sellers that those leases go beyond, they survive the closing date. So if we close in October and a tenant's lease doesn't end until December, that tenant will stay in the property regardless of the fact that there was a transfer of ownership. And then the title company will take care of transferring the security deposits on the closing statement. And then that new owner will take care of dispersing security deposits after their lease is up. Notice about sex offender registry. Interesting that it's in the listing contract, but if anybody has information about or a desire to look to see if there's sex offenders in the area, you can point them to this telephone number or that website. Real estate condition report. So right in the listing contract, it states that the seller agrees to complete the real estate condition report provided by the firm, and that they're going to fill it out to the best of the seller's knowledge. Seller agrees to amend the report should the seller learn of any defects after the completion of the report, but before acceptance of a buyer's offer to purchase. Seller authorizes the firm and its agents to distribute the report to all interested parties. So just write in here that seller is agreeing to fill out the real estate condition report. It is a state law. Seller representations regarding defects. The seller represents the firm that as of the date of this listing, the seller has no notice or knowledge of any defects affecting the property other than those on the real estate condition report. So everything that they know is a defect, they will be putting it on the real estate condition report. And I like this, a nice big old warning for the seller. If the seller representations are incorrect or incomplete, seller may be liable for damages and costs. So, Mr. Seller, we want to be straight up with information right off the bat. We want to avoid any post-close headaches. So that is probably the number one litigious reason, or the reason for any buyer to take action against a seller is misrepresentations on a seller real estate condition report. So they want to fill that out completely. Seller cooperation with marketing efforts. So seller agrees to cooperate with the firm in the firm's marketing efforts and to provide the firm with all records and documents and other material in their possession, which would be connected with the sale. Seller authorizes the firm and its agents to do those acts reasonably necessary to effect a sale, and seller agrees to cooperate fully with these efforts, which may include use of the MLS, internet advertising, or lockbox system. Seller shall promptly refer all persons making inquiries. This is an important line. Seller shall promptly refer all persons making inquiries concerning the property to the firm and notify the firm in writing of any potential buyers with whom the seller negotiates or who views the property with the seller during the term of this listing. So the seller, this is an exclusive listing contract. So even if the seller makes a connection with a buyer themselves, they are agreeing to notify us right away, and we would be handling that transaction. They cannot do anything outside of us, even though they're the ones who potentially procured the buyer. They need to notify us right away if someone has contacted them directly. Open house and showing responsibilities. So just a warning that there's a potential risk for injury, damage, and or theft during showings or open houses. So seller accepts this responsibility for preparing the property to minimize the likelihood of injury. Seller agrees to hold the firm and its agents harmless for any losses that might result from injury or theft during a showing or an open house. Seller acknowledges that the individual showings and open houses may be conducted by licensees other than the agents of the firm. I think sellers might ask that question a lot, like, you know, are you going to be the only one showing the home? Are you going to be the only one holding open houses? This is a good time to remind them that, no, you might call on a colleague to host an open house. And of course, there's going to be co-broke agents showing the home as well. There is a line in here about videography, and I want to make sure that I highlight this. So seller acknowledges that individual showings at open houses may be conducted by other licensees of the firm. Appraisers and inspectors may conduct appraisals and inspections without being accompanied by agents of the firm. So appraisers and inspectors, due to their licensing, do have the ability to be in the property by themselves, and the standards that they uphold and agreed to when they became appraisers and inspectors. Buyers or licensees may be present at all inspections and testing and may photograph or videotape property unless otherwise provided for in additional provisions. So we are giving them the opportunity to photograph or videotape the property right off the bat, unless the seller says they do not wish for a buyer to take video or to photograph the property. Termination of listing. So neither the seller nor the firm has a legal right to unilaterally terminate the listing absent a material breach of contract with the other party. Seller understands that the parties to the listing are seller and the firm. Agents for the firm do not have the authority to enter into a mutual agreement to terminate the listing, amend commission amounts, or shorten the term of this listing without written consent of the agents. So we must come to an agreement to change price, change the terms of the listing contract in any manner. That means, when I say both parties, that means the seller and us as the firm. Without the written consent of the agent, supervising broker, seller and the firm agree that any termination of this listing by other party before the date stated on the line 312 shall be effective by the seller only if stated in writing and delivered to the firm in accordance with the lines 280 or 302. If there is when I get to this section, when I'm explaining it to a seller, if there is a reason that either party want to exit the contract, you'll come to the compliance brokers if there's an issue. I will say that, we will never have an issue with ending, generally speaking, we'll never have an issue with ending a contract early. You as the agent might, but I'll say that we'll always kind of follow suit with what you as an agent and your wishes are, and depending on the circumstances with that seller. So just know that. Again, if there's any possible contention with ending a contract early, just see us. Earnest money. So if the firm holds trust funds in connection with the transaction, they shall be retained by the firm in the firm's trust account. Firm may refuse to hold earnest money or other trust funds. Should the firm hold the earnest money, the firm shall hold and disperse the earnest money funds in accordance with Wisconsin Statute 452. If the transaction fails to close and the seller requests and receives the earnest money as the total liquidated damages, then upon disbursement to the seller, the earnest money shall be paid first to reimburse the firm for cash advances made by the firm on behalf of the seller, but not in excess of the agreed commission. Probably going on too much here. Payment to the firm shall not terminate the listing. My one-liner to a seller when I'm explaining this section is, we as the listing firm hold on to the earnest money in our trust account. I do get a lot of sellers who question or have an understanding that the earnest money goes directly to them. I think the point that should be taken away from this section is that we as the firm hold on to the earnest money until closing. And if there's a dispute during the offer stages, we'll have discussion about that. Case by case basis. Last page. So delivery of documents and written notices. So just like the offer, this should look familiar to you, or the buyer agency agreement. So we need to identify the authorized delivery method. 9.9 times out of 10, it's going to be email. And so you'll check mark line 297, and then you'll put an email address for the seller, and then you'll put an email address for the firm, which will be your email address. The term of the contract is identified on lines 311 through 312. Just a note here, and to make this clear, that the term of the contract start date is different from the date that it's signed. So I, as a listing agent, might post date this term of the contract for a week from when it's actually getting signed. So when you're entering it into MLS, you are going to be looking, and it asks for the listing date and the expiration date. You're going to be looking at lines 311 and 312, not the date that it was executed by the seller and yourself. So just keep that in mind. And same with delayed showing or delayed listings, which I'll get to in a minute. You're working that 21-day period from the start date of the listing contract, which is line 311. All right, so then your seller will sign on 318. You as the firm and the agent will sign on line 329. If you have a situation where it's a seller entity, so maybe an LLC, or if it's a personal rep, the seller entity will sign on line, or the seller entity name will be put on line 325. And then the authorized signature for that seller entity will sign on line 328. So, all right, that is the contract itself. This is a continuation from last week. And now we will get into the different kinds of, I'll kind of go over this quickly so we can get into Joan's section on buyer agency.
I want to make a point on who signs the listing contract.
Oh, yes.
Comes up over and over and over. It is only binding. The person signing the listing contract, whether it's an LLC or it's a person, it means that that person is responsible for paying the commission. No more. Has nothing to do with ownership or deed or anything like that.
Thank you. Yes.
It just came up this morning. So
yeah, okay. That's a reminder. Okay, so then types of listings, MLS statuses. So in MLS, we've got a new active or active listing. A new active or active listing in MLS is a property that is available to the agent and the broker, members of the MLS. Available means that the listing can be actively shown and actively receive offers. If a listing does not meet the available requirements, it cannot be active. New listings require a new listing contract. You cannot enter listing as new with an amendment. All listings must be entered into MLS within 48 hours of the listing term date. So those dates that I identified on line 311 and 312, line 311 is the listing date, listing start date, and it must be entered into MLS within 48 hours. If you see an MLS listing in MLS and it's active or it has a new listing status, you can assume that you can write an offer on it and show the property. Active with offer indicates that the property has an accepted offer. However, the listing broker is continuing to show the property and accept secondary offers. Remember, in the offer to purchase, it does allow for the seller to accept secondary offers, and as many as they want. These listings will continue to appear in active searches. So when I'm searching for a property and when you're setting up a new buyer on an MLS search, you see this all the time. It's going to pull up all active listings and all active with offer listings. Similarly, when a buyer is looking at Zillow or Realtor.com, even if it has an active with offer status, it will show in those websites. That is a question we get a lot, or you as a buyer's agent will receive that question a lot. You might be sent a property from a buyer asking to see it, then you'll go and look it up on MLS just to verify that it is actually available, and come to find out that there is an accepted offer on it. So that is going to happen. I always think it's a nice or just another reason that that you can bring up in your buyer agency consultations, that you as having access to MLS has the most up-to-date information. So just another reason why you would want to work with a buyer's agent. These listings will continue to appear in active searches. They must be submitted to MLS within 48 hours. Unless there is a home sale contingency that has a bump clause, then the status stays active. So just like you've got 48 hours to enter in a new listing, if I received an accepted offer on my listing today, I have 48 hours to put it into MLS, or sorry, put it in MLS that it's active with offer. So sometimes, you might accept an offer on a Friday night, but want to keep it active in MLS because of the open houses. And that's completely within your right, given the 48-hour rule. You might have to field some phone calls, but just know that you do have that option. This line about a home sale contingency with a bump clause. Actually, I'll go one step further and say, even if there's not a home sale contingency, but there's only a bump clause attached to a different contingency, if there's a bump clause in the offer, then the property is allowed to stay active. And just as a reminder, that is what gives the seller that incentive to accept an offer with a bump clause. It allows them to keep the property active in MLS, so that it's not going to dissuade secondary offers for any reason. So that's why the MLS allows the property to stay active in MLS. Pending listing. So any listing that has an accepted offer and they have gotten through all of their contingencies, or if the seller has directed that they don't want to have any showings, then the listing agent can put the property into pending listing status. The pending date will reflect the accepted offer date, and you're reminded of that when you put in the listing date, or put in the pending date, excuse me. Then we've got expired listing. So the listing contract has been canceled by an amendment before the expiration date, or it just naturally expired from the original expiration date. Withdrawn listing, if a seller no longer wants you to market or show their property, but you as a listing broker do not want to release them from their contract, then the listing could be put in as withdrawn. While a listing is in the status of withdrawn, it is not available for anyone, including the listing company, to show. No showings nor marketing. So there might be other reasons why it might go into withdrawn. If you're going to suspend showings for, more than, a couple days at a time, you would want to put it in that withdrawn listing status. Sold listing, property is sold and closed. Properties must be reported as sold within 10 days of closing, or MLS may sanction, or may levy a sanction, excuse me. Pending date should reflect the accepted offer date, again, for that closed listing.
Yeah, I have a pointer I want to throw in there about withdrawn listings. On a recent professional standards panel, the broker was being charged an ethics violation because they didn't have a withdrawn amendment for the seller to sign. He just unilaterally withdrew it from MLS because MLS does not require an amendment to withdraw it. So he didn't think that he needed an amendment to withdraw it. Yes, you do need an amendment to withdraw a listing, and that's between the firm and the seller. So you do an amendment to the listing contract, putting it into withdrawn status and put it into command. Just because MLS doesn't require it, it doesn't mean that your license doesn't.
Got it. Thank you. Extended listing. So if a seller and if the home has not sold and the expiration date is approaching, you may extend that listing with an amendment to the listing contract, changing that expiration date. Delayed listing. So it is understood that unless the seller has consented to the terms of the MLS exclusion form, the listing agent or brokerage may not show a property where showings and or ability to submit offers are not being offered to cooperative agent and brokers. A property may not be delayed longer than 21 days. Sellers sign a consent form of delayed with a form called the seller's authorization to delay showings. And this form will be submitted to MLS along with the listing contract. Let me pull up a copy of the delayed form. When you want to use a delayed form is if there is still, the whole reason why this was created, if there is still work that needs to be done on the home, you want to secure that listing contract. You've got 21 days, up to 21 days to have the home in what's called delayed status. This delayed status allows for the property to be in MLS. You will identify a showing start date online, or sorry, midway through the seller authorization form. And you'll identify that showing start date in MLS when you're entering the listing, and the home will automatically go live into MLS on that showing start date. So that is key to understand as a listing agent. If you don't have all of the photos in, or if you don't have your MLS description completed yet, it will just kick live automatically. Another point to make about a delayed listing is that it is not being syndicated to the other websites like realtor.com, zillow.com, etc. It's only staying in MLS. It is a searchable field within MLS. So I, as a agent, can go to MLS, search for any delayed listings, see what might be coming up on the market. And I can actually email that link of the MLS data directly to a buyer, but the buyer is not going to be able to search for it themselves. So that's key to understand as well. I as a buyer's agent, I'm also able to schedule a showing for that first start date of showings, but I cannot schedule anything earlier than that. A note for listing agents on delayed listings as well is you as a listing agent cannot bring a buyer during that delayed period. Absolutely no showings can happen in this delayed period. It is strictly for a seller to finish up getting their home ready. Maybe you want to do kind of some pre-marketing on the property. You can do that. You can post about it on your Facebook pages, any social media. We can email it out to other agents, other buyers. We just cannot show the property. So this is the form that you would sign. Seller's authorization to delay showings from MLS service. Another note is that if you have a question about when you plan to, if there's any sort of question about when showings will actually begin, you can always extend that showing start date but with a phone call to MLS, but you cannot push it up. So just know that it's better to kind of keep that deadline or keep that showing start date closer to the listing date than pushed out if you think that it might change at all, because you can always extend it, you cannot push it up. Okay, so you as a listing agent will sign and the seller will sign. Next up, excluded listings. So if you've been in the meetings the last couple weeks, you know that we have been talking about this, kind of beating this to death. But excluded listings, so there might be a need to put the property in what's called excluded status. If you have a seller who wishes to remain anonymous, and that is the whole point of having an excluded listing, is to protect seller privacy, you can put the listing in excluded status. So you, just like with the delayed form, you will have the seller, along with the listing contract, we'll have them sign this authorization to exclude the listing from MLS. And it gives them a whole bunch of warnings and provisions regarding the clear cooperation policy. And it asks them to initial after each section. The crux of this is that with the clear cooperation policy, we need to have an understanding that the seller cannot market, we as agents cannot be marketing the property publicly. Otherwise there will be hefty fines. If we are publicly marketing the property within 1 business day of those marketing efforts, we need to get the property into MLS right away. Seller has an understanding that the property will not be in the MLS database available to real estate agents and brokers who subscribe. And it's not going into any general public websites through MLS. MLS will not make available information on seller's property to other real estate websites used by the general public. And real estate agents, brokers, and members of the public consequently may be unaware of the availability. So again, just giving sellers a warning. So, the best way, in terms of the likelihood of getting the highest offer with the best terms, the property will go out onto the MLS in a live listing manner, not excluded from MLS. So basically it's just a warning to the sellers that it's not going to be it's not going to be out to everybody who may have an interest in the property. And they need to be aware of that. And here again, section E, the reduction in exposure of seller's property to other real estate offices and prospective buyers may reduce the number of offers and adversely impact the price or terms the seller receives. So again, the best thing a seller can do is put it out live on the listing market, on the open market. If the decision is made to publicly market the property, listing agent must input the property into the MLS within 1 business day. So again, those are all things that the seller needs to sign off on and have an understanding. So again, if you have an excluded listing, you are limited to how you can promote the listing. It's the best rule of thumb is verbal only. So I can make phone calls about the property. I cannot share any information via written method. So that means going on our Facebook pages, the internal Facebook pages, etc. Single party listings. I'll quickly go through that. A single party listing in the eyes of MLS, it is similar in terms of the fact that you cannot publicly market it. But a single party listing is generally reserved for these kind of like natural coming together of a buyer and a seller, where you might have a seller or a potential client, 2 months ago, someone reached out to you and said, I'm thinking of putting my house on the market in a year. And you hear of a buyer who is looking for a property that fits this potential listings description. A buyer's agent and a seller's agent might bring the 2 parties together. Let's say I had this opportunity that I was told about, again, 2 months ago. And, with conversations with Joni, I hear that she's got a buyer for this. And I say, oh, I've got a seller who might be putting their home on the market next year. Maybe we can put something together sooner than that. That's kind of just like, I really want to hone in on this idea that a single party listing is not a marketing tool. It is just this kind of organic coming together of a buyer and a seller. In other times, a single party listing might be used is if as a solo agent, bring 2 parties together. Another thing to note about a single party listing is that a single party listing is only applicable for that named buyer on the listing contract. It is not an exclusive listing contract. So a buyer, you know, if I have a single party listing contract with my own buyer, that does not prevent Joni from coming in and having her own single party listing contract with that same seller and her own buyer. So the terms of the listing contract are only applicable to that particular buyer. So you as a listing agent, you know, as you're talking through these kind of different scenarios with a seller, and you have a seller who wants to remain off the market or out of MLS, you're going to want to do an MLS excluded listing. That gives you the most protection as a listing agent. So in terms of filling out a single party listing, you would on the WB1 be crossing out at the top the line exclusive right to sell. And in lines 149 to 150 in the non-confidential information, you would write, this is a single party listing for named prospect blank, and then you would put that buyer's name there. If more names are added, you can use an amendment to the listing contract as well. So there is a difference between the two in terms of, again, with MLS, how you market it is not different, meaning you can't really market it. So everything is verbal. And Joni and I will always say, get it listed, delayed or excluded. The best thing you can do is get a active live listing. That is the best thing you can do for your sellers. Okay. Any questions on listings before we switch gears? Okay. Well, I'm going to hand it over to Joni now. We're kind of doing a two-parter here because of last week's snafu. So we'll get into the responsibilities of a buyer agent.
Good. Yeah, this is sort of a short reminder. Years ago, there was a challenge in trying to get real estate agents to actually use buyer agency, and to convince the agents why buyer agency was actually the best way to use their skills, use their negotiating skills. And it was difficult for especially older agents or seasoned agents who had been using sort of an assumable buyer agency. They just didn't have any agreement. They just assumed they're working with a buyer, they're going to protect the buyer. When the law was passed, and there was a considerable learning curve to get that. Today, however, almost every agent signs up buyer agency with a buyer they're working for. Very few customer relationships are now. And one of the things that sort of cautions why I bring this up is because I think because it's so automatic that we sign up buyer agency with the buyer, that we forget really what the responsibilities and duties are to a client when we have buyer agency with it. There's some very important, there's some very libelous potholes that you can fall into, and so that's what this is all about. There are also some buyers that you probably shouldn't get buyer agency with, and do work with them as a customer. Represent the seller and the seller's listing firm instead. And that's what you are if you have a customer. You're representing the seller, you're representing the seller's firm. So if it's a Shore West listing, you have a customer, you are really acting in the interests of Shore West and their seller. And when not to offer buyer agency, buyers who won't be loyal, who will just go to every open house and talk to every listing agent and run all over the place and do their own research and things like that. They're not worth your time and skillful efforts. When you cannot follow up with a buyer's needs, the buyer has very unrealistic needs, wants to buy something for 150 in Whitefish Bay, like tomorrow. I wouldn't sign that person up as buyer agency because you may not be able to fulfill your duties. And the same thing when they have exaggerated expectations. You have to be able to realize that financially, and as far as lifestyle is concerned, these buyers have a realistic view of what they need and what they want, and you can go ahead and sign buyer agency with them because you can do your job. If it's unrealistic, if they're difficult, try a short buyer agency contract, or just hold off and work with them as a customer until maybe they're ready to negotiate an offer. If you're working with a buyer as a customer, you do need to fill out that customer disclosure form and send that with your offer. So they say, when do you have to have buyer agency? It used to be you had to offer it right away when you first started working with them, and they changed the law on that. And now what the law is saying is that you have to offer the choice. You have to be able to explain to a buyer, these are the choices you have. You can work independently as a customer of mine, or you can utilize my skills, my experience, my expertise in negotiating, and I will represent you. I'll get in the boxing ring with you instead of you. So I'll get in the boxing ring with the listing agent and we'll negotiate the best offer for you. That's my role as a buyer's agent. But you don't have to have it signed up as soon as you start working with a buyer. But you really must delineate the choices that they have. And again, I absolutely drill this all the time. One of our most important skills that we have as a real estate agent is our skill to negotiate. It's a skill that you need to develop. It's a skill that you may have naturally, but you need to develop this skill, practice the types of negotiation so that you are earning your money, which is, I think, what any kind of an agent is supposed to do with a client. The buyer doesn't have to sign the agency agreement right off the bat, as I said, but they can wait until you're about ready to make an offer, because that's when you're putting your negotiating skills to work, which will include negotiating the price, actually negotiating an accepted offer, negotiating the price, and eventually negotiating the inspection and the contingencies that follow. So the client also has part of this agreement responsibilities, and I think a lot of you who just automatically use buyer agent forget about this client responsibility. The client in this agreement agrees to cooperate with the firm, and remember, the buyer agency is with the firm, not with you, the agent. You are a representative of the firm. And to provide them with accurate copies of all the relevant records, like all their financing, things like that, documents, share confidential information that may be pertinent to their purchase with you. So they can't hold things back and make your job more difficult. They have to be reasonably available for showings. I can't do this. I can only work, 3 to 5 on Wednesdays, and, only look at houses 3 to 5 on Wednesdays, or things like that become very difficult. This agreement is between the firm Keller Williams, you, the representative, and this buyer who supposedly has the intentions of buying. The client shall promptly notify the firm in writing of the description of any property the client locates, and shall inform other firms, agents, seller, property owners with whom the client comes in contact that this firm represents client as buyers, and refer all persons to the firm. Shortened out, that just means you got to make sure that you educate your buyer when they go to open houses. The first thing out of their mouth is saying, I work with Steph at Keller Williams. I mean, you've got to inform everybody. You can't say, oh, I forgot. I'm not sure whether I told the listing agent at the open house that I was working with you or not. That can become a big major slice of information in a procuring cause. So they have to understand this, that that's part of their responsibilities in this agreement. And so as it's stated in the buyer agency agreement and it's stated in the listing agreement, it lists the duties that are owed to both a customer and a client. All parties are owed fair and honest brokerage services. That's what you are offering. Reasonable skill and care in providing brokerage services. You are providing accurate information about market conditions to all clients and customers. You are disclosing, if comes to you, material adverse facts. You must. Protect confidentiality to both customers and clients. Everyone, all parties gets that protection of confidentiality. You have a duty to safeguard trust funds. Earnest money trust funds are a major important role in these transactions, and the misuse or the sloppy use of trust funds can you can lose your license. Present contracts in an objective and unbiased manner and disclose the advantages and disadvantages of the proposal. You become a presenter, and it must be objective and it must be unbiased. You can't favor a certain agent, you can't favor a certain contract. You have to present them all in an objective and unbiased manner. So that's what you owe to all parties, but you owe additional duties to this client, to this person you've now signed up with in a buyer agency agreement. Don't forget, these are important. This is what establishes you as correctly offering the buyer agency that you're proposing. Provide information, advice on real estate matters that affect the transaction. You can't provide legal advice, but you can certainly provide real estate advice. And the better skilled you are, the more knowledgeable you are, the more prepared you are, the better service you're providing. All material facts, not just adverse material facts, but you have to disclose all material facts to your client about the property. Agents and firm will fulfill obligations and lawful requests that are within the scope of the agency agreement, not outside of it. We're not going to be giving financial advice, legal advice, tax advice, but within the real estate advice, we definitely must fulfill those requests. We are, as I said, the most important, we are negotiating for the client. Client stands by while you and the listing agent negotiate the terms. And the definition of fiduciary, the agent will not place their interests ahead of the client's interests. Don't be worrying about what commission you're going to get. Don't be worrying about what property they're going to buy. Their interests have to come before your interest. This is a chart I made up 1,000 years ago, and I've reviewed it over and over, but it's a nice sheet, and it is available in our global library, of showing the advantages of working as a buyer's agent. Again, this was a chart that we had to use a lot to convince our agents to use buyer agency before they convinced their buyers to use buyer agency. Now it's a matter of practice, and we don't need to make that convincing, but that chart also shows you the differences, what your obligations are when you do sign up that buyer agency. And you can give a copy of this chart to your buyer to remind them on what your distinctions and differences are. I don't need to go through them, I think. So I do want to bring this up. In now using buyer agency so often, I want to remind you that it is very similar to a listing contract, which Steph has just gone over. So many of the elements of a listing contract are identical in a buyer agency. And basically what it is saying we are going to be representing you as a fiduciary in this transaction that we have. And they're outlining, both contracts are outlining the duties, the fiduciary duties between the firm and its agent with the client, either the buyer or the seller. I remember going to a training one time, there were about 200 of us in a room, and the trainer was talking about buyer agency, and he said, how many of you now have a buyer client in you're working with? You know, and most of us raised our hand and everything. He says, you're all wrong. You don't have one, your firm has one. And it's a good reminder that you are only representing the firm in this buyer agency, but this fiduciary duty is Keller Williams and your buyer. A fiduciary duty, and I looked up the definition to make sure that I included everything, is to act in the best interest of another person or persons. To act on behalf of a client in good faith, putting the client's interests over their own interests. It's a very legal position to take, and in signing a buyer agency agreement or a listing contract, it puts you in that legal obligation. At the end of a contract, each can protect your business interests that were made within that contract term. So in a listing, as Steph just went over, you can give the protected buyers who looked at your listing during the listing term, you can protect them for a year after that listing expires. Exactly the same situation in a buyer agency agreement. You can protect the properties that you showed your buyer for a year after your buyer agency expires. So make sure that you fill out that list of properties that you and your client looked at if your buyer agency agreement is about to terminate. So it is important. And again, it's the same thing. Fill that out. Steph or I sign it because it's an agreement. It's an amendment to the buyer agency agreement that you do fulfill this. So make sure that when you're talking about your buyer, you are correct in saying whether that buyer is a client or a customer. Last slide, I think. Steph and I get lots of questions about the ending of a buyer agency agreement. Yeah, how do you do it? I'm working with this buyer that I just met, and they're in a buyer agency agreement with somebody over at First Weber, and they want to get out of that, and they want to work with me and all this. Lots of questions about that. The buyer agency agreement ends at the date on the contract with protected addresses sent to the buyer. Or it can be an amendment to the buyer agency agreement that the date can be changed. It can be moved backward, say to the current date, terminating it as of today, or it can be moved forward, extended, like a listing contract can be extended. These need broker signatures since the agreement is with the firm. Either party can instigate the change of a termination date since this is a service agreement, which means if it's not working out for you or if it's not working out for this client, you can terminate these agreements. They don't come with any hanging on obligations like you have to pay me for my expenses and all this sort of stuff, unless you put that in your buyer agency agreement. You can add those provisions in your agreement saying if this is terminated before the expiration date, buyer to compensate buyer's agent for expenses or up to $1,000 or something like that. But you have to have that in the buyer agency agreement in order to try and enforce that. We've had calls from very frustrated agents saying, you know, all that I did for them, all that I've paid for, you know, all this sort of stuff. and now they want to walk out, or they just bought a for sale by owner or something like that. That buyer agency agreement does say that we can enforce getting paid our commission, but it has some contingencies to it. You have to show that something that you did was incompetent, whatever, not fulfilling the duties of the buyer agency agreement. Rarely do we go after a buyer and make him pay that commission to our agent. But there have been some cases where we've attempted to do so. But they have to prove that there's something that they did not, that the agent did not do, according to their license. So that's pretty much it as reminders. I'm going to go over some of these points at tomorrow's team meeting too, for the general agents in the firm, but it is something to keep in mind. It's not an automatic signing on. It's something that you really need to understand what your responsibilities are if you are a buyer's agent. Any questions about any of this?
Yes,
You're
I have
good?
a question.
Sure.
If a business is being operated out of a property, at what point should that be disclosed to a potential buyer?
Right away.
Well, yeah, I mean, any disclosure, that affects the property should be disclosed right away.
Okay.
Yeah.
Should it be included in the listing?
Yes.
Okay.
Yes, it should be available in MLS information.
Okay, thank you.
Yeah, I mean, it's best when all those things are known before a property is selected and attempted to be shown, so that they know everything up front.
Okay,
Okay, thank you, Lito.
thank you.
Next week, Kathy Shaw from the Falk Reuben Gallagher team is going to be our guest, and Joan and I are going to we're going to do a mock buyer consultation, and Joni and I will be acting as the buyers, and Kathy will do a consultation on us. I think it's a really good way to show how your buyer agency consultation should be structured, the most important points to go over. Yeah, so I'm looking forward to it. It'll be good to show you guys. So I'm sure you've seen examples of this in your productivity coaching as well. The kind of, having multiple perspectives is always good. So please tune in for next week.
Very good.
All right. Thank you, guys.
We're always here to help. Give us a call. Thanks.
Bye.